Welcome to another program of Friends of the Court, Law Made Simple with attorney George Bassias. George, thank you for joining us.
Thank you for having me on your show again.
Tell us, what are we talking about today?
Today we're going to discuss consumer debt, a situation where people owe money to credit cards and debt buyers and find out that they have a judgment against them. Sometimes they find out because they found out that their bank account has been garnished, or sometimes they get a letter sent to their employer that they're about to garnish their paycheck. And this is a good time to talk about it just before Christmas, because there are individuals out there that have received this information, and seeing that the holidays are coming, they're concerned that they're not going to have access to their money to buy the presents that they want to buy. So to make things easy, what should you do? That is the question.
Well, I have to ask for everybody who didn't make it to college. You use the word garnish, and I think of that something on the side of my plate with a hamburger. What does it mean when somebody garnishes your wage? Anything to do with vegetables or parsley?
Well, it's similar, because when they garnish your wages or they garnish your bank account, you're not going to be able to get that parsley to put on your plate. What it means is that they have an attachment. They've got a judgment against you. They sued you. Whether or not you were served is an issue that we'll get into in this discussion. But at some point in time, they sued you, they obtained the judgment, and now they gave the judgment to the marshal, who is attaching your bank account or attaching your paycheck, and that's called the garnishment.
All right, so let's set this up here for everybody. Almost all of us use credit cards every day. And so somebody has maybe overspent the money that they have and not been able to follow through with a promise when they went and bought something, or maybe a recurring monthly payment. And somehow they've accumulated some debt with the credit card company. Is it the credit card companies who go after the person, or?
Yeah, it's a credit card company. Sometimes they charge it off. They'll write it off, and they'll take that charged off debt and they'll sell it to a debt buyer. And the debt buyer steps in the shoes of the credit card companies, and the debt buyer goes after the individual.
So it doesn't sound very fair, but tell me, how common and how is it epidemic, and how many people are suffering from this kind of problem?
It's very common, and it doesn't go away by itself. People have to be proactive. I would say, do not ignore the summons and complaint that you get served, whether a process server gives it to you, or you find it in your mailbox, or you find it mailed on your door. Do not ignore it. It's not going to go away by itself. And if you find out that there's a judgment against you, that's going to come back and bite you on the butt. Do not ignore it. There are things that you can do without an attorney initially that will make your holiday season a lot better. Now, I also want to say one thing, that whatever we discuss on this program obviously does not apply specifically to an individual. My advice would be talk to an attorney of your own choosing. But what we're going to discuss here is a general discussion about what you can do in those scenarios.
Yeah. So in the very beginning, when you have some debt with your bank or credit card, sometimes even the bank will let you know. But we're talking more than that.
Yes.
And does it matter how much money you're in debt, or is there a minimum from which the credit?
Well, if it's a little bit of money, when I say a little bit of money, I would say less than $2,000. Chances are that that creditor will not sue you. But I can't really put a specific amount on it, because I'm not in the creditor's shoes right here. I'm here talking from the perspective of the debtor. What happens a lot of times is they'll sue somebody, and you'll find out years later that they have a judgment against you, and what was $2,000 is now actually $6,000 with the interest that it's earned. And once you find out, there's certain things that you have to do to get rid of this judgment immediately. And you, as a pro se debtor, can do it even without the use of an attorney.
Before we get to what people can do on their own, before using an attorney, let's go back to our debtor. You said a judgment has been ruled against you, or you have a judgment against you. So it's not just that the credit card company or the agency that they hand the job over to a collection agency, either one of these groups has gone before a court.
Yes.
And I think the word is ex parte justice, maybe, where one party wasn't at the hearing and a judgment is given against the creditor or against the debit holder.
So the application cannot be ex parte in consumer debt cases. What happens is they prepare and they file a summons and complaint and they serve it. Oftentimes the service is bad because the individual no longer lives at that address. And if they can prove to the court that they did not live at that address at the time that the affidavit of service of the creditor says they were served, they can have the case not only open, but oftentimes dismissed. And if the statute of limitations is expired, which sometimes is 6 years, sometimes is less, the case will be dismissed and they won't be able to bring the case again.
Wow.
And that's one of the key things in setting aside these judgments is when an individual makes an application to set aside the judgment, it's very important to look at the affidavit of service, to demand that the creditor's lawyer produce that affidavit of service. And if you look at that affidavit of service and you can show the court, hey, I did not live at that address. Look at the lease that I had in this other location. Or look at my driver's license since this time period, which shows I did not live at that address. Or look at this affidavit from my landlord, which proves I did not live at that address. There's different types of proofs that the court will require. They put it on for hearing sometimes, but usually if the service is not good and a long period of time has gone by, the creditor's attorney will not be willing to do that hearing. They'll just outright stipulate to discontinue the case.
How does a debt get from a few $1,000s to more than that? Where does that happen?
Once they get a judgment, once you default, it stops accruing interest. So they go to court and they get a judgment against you, and they ask the court to put interest on it from the date of the judgment and on. So it begins to earn interest. I'm not sure, I think it's like 9% a year. And it accumulates and it accumulates, and they put their attorney's fees and costs. The attorney's fees and costs are not that much, but the interest can become significant. It can increase significantly over a period of time. Most of the situations people find out through a garnishment on their bank account or at their place of employment that there is a judgment against them, and people panic. They generally panic. And the purpose of this today is to tell people, whether or not you have a lawyer, you don't have to panic, especially if you live in New York City, because the New York City courts are very concerned about situations where creditors, attorneys have gotten judgments against people without the proper service. So they've created a consumer debt department where the creditor has to actually label the summons and complaint consumer debt. And they're very concerned about it. They look at it very carefully, and they made it reasonably easy for a pro se debtor, pro se means somebody who doesn't have a lawyer, to go into court and to set aside that judgment by themselves.
In the court, though?
In the court. In fact, the court even provides you with free lawyers. There's an organization now in New York City called NILAG, the New York Legal Assistant Group, and you can request one of those lawyers to help you out with your application when you actually appear in front of the court on a motion.
Wow.
So typically what happens is you go to the court, you let the clerk of the court know, hey, I got served with this judgment. My bank let me know there's a judgment, there's a garnishment on my account, or my employer found out, got served by the marshal, they're going to execute my paycheck, but I have no idea who this company is, Midland Funding or Catch LLC, or there's a series of debt buyers. I don't know who they are. I don't believe I owe anything to them. I don't believe I was ever served. Or it might be a creditor that I had this bank account, this credit card, Discover 10 years ago. I didn't realize they sued me. I was never served. So the clerk will give you a series of paperwork that you filled out. You just say, I was never served, or I dispute the amount of the debt. I don't believe it was that high. And they'll send you in front of a judge, and a judge will sign an order restraining the marshal and restraining the law firm from collecting against you until this motion is heard 3 weeks later, a month later. Now, at that motion, you can request a volunteer lawyer. You can request the help of a volunteer lawyer that's more experienced than you in arguing your case.
Yeah.
But one of the key things that I will tell the viewers is when you go to this motion, ask for the affidavit of service. And if they don't have the affidavit of service, let the court continue the case to another date with the instructions that the creditor's lawyer produces the affidavit of service. And when you do get the affidavit of service, if it lists an address that you did not live at, or if it says the summons and complaint was served on Ian Snow and you never lived with Ian Snow, you have to make the argument that the service was never proper. And if the statute of limitations has expired on the case, and the court puts it on for a hearing, the case will be dismissed. You will no longer owe that debt.
Wow. And I think, is Visa and American Express and Discover, this is what they're doing when they let people use their cards who've accrued debt?
American Express is one of those companies that will not that frequently close the debt, charge it off, and sell it to a debt buyer. If you get sued by American Express directly, that's a much harder case to dismiss. But if they have a judgment against you, again, if you show that the service was improper, that's always the first thing that you got to look at. That's the best way to get one of those dismissed, by showing that service was improper. But if the service was proper, because there's a presumption that the affidavit of service is correct, because this is an impartial person that served you, so there's a presumption that it's correct. But you can overcome that presumption. You can rebut it by showing, hey, I didn't live there. If you can show you didn't live there, if you rebut it, the court will put it on for a hearing. And most of the time, the creditor lawyer will not go ahead with the hearing if you have good proof that you didn't live there. They won't bother. It's too long period of the time. They're no longer working with that process server. A lot of things happen, and the court will dismiss it.
George, what about mailboxes, which are just too stuffed with envelopes and flyers from the supermarket, and somebody says, I don't recall seeing this even come through. And you go to the court and say, we have a mailbox, and sometimes some stuff's thrown on the ground. And do you see that kind of argument being made, that somebody didn't receive proper notice?
Well, you're not supposed to, as a process server, you're not supposed to put the summons and complaint in the mailbox. You're supposed to go to somebody's house, ring their doorbell or knock on their door. If you go at least 2 times, then you're supposed to nail and mail, which means you're supposed to stick it on the door or stick it on the wall next to the door. But oftentimes they do put it in the mailbox, but they're not going to say that in their affidavit of service. They're going to say they affixed it on the door or on the wall. And if it's your word, you're the debtor. If it's your word against the process server, the court's going to believe the process server, because there's a presumption in favor of that affidavit. If they got the address right, you got to prove it was put in the mailbox. You're not going to be able to prove that. If it's your word against their word, the court's going to believe them.
Wow. And we think of somebody like a bounty hunter. Are there any process servers who would make you an offer at the door if you answered the door and said, look, I have a machine that'll take the money right now? Or is that unheard of?
That goes against the purpose of a process server. That's why there's a presumption in favor that the service was done properly, because this is a neutral party that's hired for the purpose of service. If they worked for the attorney's office, then they would not be credible. You could always raise that at trial and say this is an employee of the attorney, but you can't do that because the process server is neutral. They can be hired by anybody. They can be hired by the debtor in filing a subsequent lawsuit against the creditor. It's a neutral party.
Right. And is there a typical type of debtor? Are we talking about somebody who's maybe bought a camera or some running shoes and ended up with a 300 debt, or someone who bought a new washing machine and dryer? Is there a typical kind of debtor, or is it somebody who maybe maxed out one card and got debt and went and got another card? Before they know it, they might have a few debts from different card agencies. What do the debtors look like?
Well, the debtors all look alike. You can't really tell. Sometimes it could be somebody as sophisticated as a medical professional or an attorney. There are attorneys with credit card problems that have credit card debts.
Driving a great car.
Yes, exactly. So the debt can go anywhere from $10,000 to $200,000. So you can't really tell by looking at somebody that they're a debtor. The main thing is that there are two kinds of consumer debt lawsuits: direct creditors and debt buyers. Direct creditors are much harder to get dismissed because you're dealing with the creditor directly, and they, at some point in time, the creditor, an employee of the creditor, will make a motion for summary judgment if you're fighting the lawsuit, if you answered it, and they'll get a judgment against you. But a debt buyer will need to offer a lot more in evidence to get that summary judgment. It will have to be an affidavit from the debt buyer and an affidavit from the original creditor. They'll have to attach the agreement to show that they owe the debt. If they don't survive the summary judgment motion, they'll have to go to trial. They'll have to produce a witness from the original creditor and from the debt buyer, which most often than not, they don't bring them to trial. Statistically, if you get sued by a debt buyer, someone other than the original creditor, you have a much greater chance of getting that lawsuit completely dismissed, or at the very least getting a very good settlement agreement with them. With the original creditor, most of the time, you're lucky if you get a 50% or 40% reduction in a settlement agreement. One of the things I should say that when you settle for less than the full amount, you're going to get a 1099 at the end of the case, which means that although you reduce what you owed by 40% or 50% or 60%, you're going to owe some money to the IRS because they're going to send you, for whatever's forgiven, that's income to you. Mm-hmm. So the best scenario is where you get sued by a debt buyer, you fight the case, you get it dismissed, and nobody can give you a 1099 because you got the case dismissed.
Mm-hmm. Mm-hmm. Wow. And for credit card debt, some people have told me they managed to buy a home with their credit cards.
So if you're a first-time home buyer, you might qualify for a FHA loan where they provide 95%, and then you use your credit cards to put the down payment and the expenses, which could be minimal. Or if you're a veteran, you get a 100% loan, you might be able to do that. You use it for the down payment. There are people that have $100,000 or $200,000 in line of credit. It's possible that they could buy a house for it, a house with their credit card. So those are few and far between, those individuals. Usually people that have credit that is that good can easily get a mortgage. So it would make no sense to buy a house with your credit card when you could get a low interest rate mortgage. Most of the time people that have judgments against them from credit cards are people that may want to consider filing bankruptcy. But sometimes you get a situation where these people are either homeowners and they have too much equity in their house, so they don't qualify for bankruptcy, or their income is too high and they don't qualify for bankruptcy. Some people resort to hiring companies to do debt settlements. I would say be very careful. There's a lot of con artists out there. They'll take a lot of money up front, high monthly payments, and then they don't settle all the debt. You got to be careful, very careful with that. Go with a not-for-profit agency. Those are the best agencies to use. But again, remember, with these debt consolidation companies, when you're done with the payments, you will get a 1099. Mm-hmm. And it's just my opinion that most of the time you'll get a better settlement when you do it yourself. You do the settlements yourself. For example, if you wait until you get sued, even though it's scary to go to court, you can usually get your best settlements in court.
Wow. So what, have you seen cases where responsible people lost their grip or their management of their income and outgoing expenses and found themselves getting a summons and having a judgment rendered against them and thinking, how did this happen to me? I mean, I'm a responsible person, and before they know it, what have they got? Have they got a nightmare on their hands?
Yes, unfortunately, we live in a very difficult time where things are very expensive and people get easy access to credit cards and they come inconvenient. For example, now with the holiday seasons, we feel like we have to get people gifts, and sometimes our children expect certain types of gifts and our spouses or significant others expect a certain quality gift, and you don't want to disappoint them, and you happen to have this credit, so you go ahead and you buy that gift and you worry about it later, and things happen. You might lose your job, you might get disabled, you might go out on workers' compensation, and you can't maintain these payments. It happens to the best of people. It can happen to anybody. It can happen to factory workers, it can happen to doctors and lawyers. There's just some people are better than others at hiding it, but it happens to anybody. It doesn't discriminate. Anytime you owe more than $5,000 in credit cards, you're starting to get into trouble.
Yeah.
No matter who you are. Because something might happen that might upset the balance of this monthly payment that you're making, and boom, you're in trouble. So the one thing that we didn't discuss is, what about if there's no judgment and you just got served with a summons and complaint?
Right.
So in that scenario, I would say that as a pro se debtor, somebody who's not represented by a lawyer, within 20 days, you should go to the courthouse and tell them, look, the clerk of the court, I got served with the summons and complaint. I'm being sued by this credit card. Can you help me prepare an answer? And they have form answers that they help people pro se. They also have different departments of volunteer lawyers. I forget the name of the volunteer lawyers that can help you prepare answers on Friday. For example, in Queens Civil Court. I had it off the top of my head, but the clerk himself can give you a sample answer, and you can prepare an answer, you could file it with the court, and you can mail it to the attorney so that you prevent the attorney from being able to get a default judgment against you. Because if they get a default judgment against you, the next thing they'll do is they'll garnish your wages and they'll garnish your bank account.
Right. Suppose they do that and they do get a judgment. How does it affect does it go back to your credit score, among other things, in the future?
Yes, of course, a judgment will appear on your credit score. Anything that's negative on your credit score can only be on your credit score for 7 years. So you could have a judgment which is good for 20 years, but after 7 years, it won't show on your credit report. You could have excellent credit. You could have an 800 credit score and not realize that there's a couple of judgments against you. And you'll find out there's a couple of judgments against you when you deposit a large sum of money in the bank, and all of a sudden your creditor attaches it.
Suppose somebody says, look, I need help with this. I'm not going to represent myself. The word is pro se, meaning
Yes.
when you represent yourself.
Yes.
Suppose somebody says, I really need some help with this, but they're thinking, here I am now asking an attorney to help me, but I've got debt to begin with. How can I pay an attorney if I'm trying to pay off debt? It seems like they're getting more debt.
Well, again, there are volunteer lawyers in the court, so that's why it's important to put an answer in, and when it comes up for any type of appearance in court, you can request a volunteer lawyer that will negotiate on your behalf. Or when you set the judgment aside and you're there on the motion date, you can request a volunteer lawyer. There are some lawyers that do it as a practice. I'm a bankruptcy lawyer, but incidental to my bankruptcy practice, there are many situations where people have consumer debt problems that can't file bankruptcy, and I have been hired. I don't charge exuberant fees for consumer debt. I'll give you an example. Somebody came to see me the other day. There's a $16,000 judgment against them. I instructed him how to set it aside. I said, when the court date comes, you can hire me. What I require is $1,500 up front and $1,500 at the conclusion of the case. And that applies whether I settle the case or whether I get it dismissed. I don't charge by the hour. It's a flat fee. I treat it like a bankruptcy case because it's the same amount of work involved as a bankruptcy case. If it's an original creditor, probably going to settle the case. I'll get a better settlement than the pro se debtor will. If it's a debt buyer, I'll probably get the case dismissed. In this particular case, the guy with the $16,000, it's a debt buyer. So I could probably get it dismissed. So I think $3,000 is a very small fee to pay to get rid of a $16,000 debt.
Right, and then you'd also handle the technical and the filings and appearances and following it.
I'm kind of like my cousin Vinny when it comes to that. You'll think I'm sleeping on it, but when it comes down to the hardcore things that happen in the case, I know exactly what I'm doing. Right. I had a client recently that was second guessing me a lot, kept texting me, kept calling me, kept emailing me because he had another lawyer on a consumer debt case and that was denied setting it aside. And he hired me, and I think his significant other was the one that was very suspicious, and he just drove me nuts. I kind of regretted taking the case, but I did wind up getting it dismissed, and then he wanted me to handle the case that the other lawyer messed up, which to my surprise, he talked me into it. I felt sorry for him because he was actually crying on the phone, and to my surprise, I wound up opening that up and got it dismissed also. So.
Sounds like law and psychiatry and psychotherapy are maybe closer than we might realize.
Yes, definitely, definitely.
Don't forget to subscribe to our channel. We're on LiveOne.tv, and this is our series, Law Made Simple. And George, I hope you'll come back real soon and talk about another topic for us to learn from.
I will come back again, and I hope in the future to assist you in interviewing other lawyers.
Great. We've talked about it, and that's coming up for the viewers soon. Thank you and good day.
Thank you.